Jefferson County Court at Law number 2 is back in session and cause number 333072. Case is styled the state of Texas versus Charles Jason Kramer. Mr. Kramer, is that your full name?
Yes, sir.
How you doing, Mr. Kramer?
Good.
Mr. Kramer, now you came up here earlier and we went over this document that is titled Judge's Explanation of Rights to Defendants Without an Attorney, and the document that is titled Waiver of Counsel for Purposes of Enter a Guilty Plea or Proceeding to Trial. Now, are you making any changes to these documents or not?
No, sir.
Okay, so Mr. Shearer, Mr. Kramer case is being reset. Is that? Oh, you want a trial? Okay, let me do this. Hold on a minute. Okay, now, Mr. Kramer, based on your responses and based on these documents, you'd like to represent yourself, you're waiving your right to have an attorney. There are some questions that I must ask you, and that's pursuant to the case of Ferretta versus California, 422 US 806. And the first question, I'm gonna ask you a series of questions. I just need you to answer. Well, first of all, raise your right hand again. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. Now, Mr. Kramer, have you ever studied law?
A little.
You said a little? Okay. Now, have you ever represented yourself in a criminal action?
Yes.
Yes, okay. Do you understand the charges against you?
Yes, sir.
Now, Mr. Kramer, what are you charged with?
Resisting.
Okay. Now, are you aware of the maximum penalties for your charge?
About a year in prison, I think.
Okay, yes, a Class A misdemeanor. Range of punishment is 0 days to a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Do you understand that?
Yes, sir.
Now, are you familiar with the exact legal elements of the charge? That is what has to be proven.
Yes, sir. But I'm having problems right now. The city of Port Neches hired the Bradley Law Firm to deny my FOIA request.
Let me do, now, in reference to what you just mentioned, actually, this court, it doesn't have anything to do with that. But what I'm asking is, I just need to ask you a series of questions for the court to determine whether or not you should represent yourself, okay? Now, the question that I stopped at, are you familiar with the legal elements or what's required for this charge?
Yes, sir.
All right. Now, do you understand that if you are found guilty of this charge, what are the consequences?
Yes,
What-
sir.
Okay. And what are the consequences?
$4,000 fine and up to a year of imprisonment.
Okay. Now, do you realize that if you represent yourself, you are on your own? In essence, you can't get any assistance from the court.
Yes, sir.
Okay. As a judge, I can't tell you how you should try your case or even advise you as to how to try your case. I cannot help in any way. Do you understand that?
Yes, sir.
Are you familiar with the Texas rules of evidence and the Texas case law?
Yes, sir.
Do you realize that the Texas rules of evidence and the Texas case law govern what evidence is admitted? And in representing yourself, you must abide by those rules.
Yes, sir.
For example, how do you conduct a voir dire examination?
What examination?
A voir dire.
Not
Voir
sure
dire, voir dire.
Not sure what that is.
Okay, commonly means how do you know how to pick a jury?
Oh, yes, sir. Well, I understand the process. I had to do it as my tickets in Nederland a few weeks ago. So,
Okay.
um,
Now, what are the grounds for excusing a juror for cause?
we got conflict of interest.
So you could strike. So that's the grounds for excusing the juror for cause.
Yes, sir.
Okay. What is hearsay?
Something someone else, this third party speech, I guess, they put it.
What are some exceptions to hearsay?
I think there are any.
Well, they are rules, they are exceptions to hearsay. Do you know the rules, the exceptions to the hearsay rule, which are in the Texas rules of evidence?
No, sir.
Okay.
I guess it's a signed document or something like. I'm not really sure.
Okay. What is proper impeachment of a witness?
For impeachment of a witness. Not sure.
What is character evidence? When is character evidence allowed?
I guess that'd be if you're trying to establish someone's pattern of behavior.
Do you know when and how to make proper objections?
No.
Do you know when and how to move for a directed verdict? Okay. Do you know how to proffer or to offer evidence to protect the record for an appeal?
No.
Do you know the proper grounds for a mistrial?
No.
Are you aware that failure to timely move for a mistrial may waive crucial mistakes made by the state or this court?
I wasn't aware of it until you said it.
Okay. Do you know how to request and object to jury instructions?
No.
Are you familiar with the Texas Rules of Criminal Procedure?
I've looked over it. But not as familiar as I'm going to need to be for trial.
Okay. Do you realize that those rules govern the way in which a criminal action is tried in court?
Yes, sir.
Now, I must advise you that, in my opinion, you would be far better defended by a trained attorney or trained lawyer than you can be by yourself. I think it is unwise for you to try to represent yourself. You are not familiar with the law. You are not familiar with the court procedure. You're not familiar with the rules of evidence. I would strongly urge you not try to represent yourself. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties of representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
It depends on the time frame that I have to prepare for the trial. Because right now I'm having a problem getting the evidence that I requested because they won't release the body cam footage from the officer. So they filed for seek a decision with the Attorney General about whether the information is from public disclosure.
Okay, now, but I'm gonna ask my question again. Now, in light of the penalty that you might suffer if you are found guilty, and in light of all the difficulties representing yourself, is it still your desire to represent yourself and to give up your right to be represented by a lawyer?
Yes, sir.
Now, is your decision entirely voluntary on your part?
Not exactly completely voluntary, because if I had unlimited funds, then I'd hire myself an attorney, but it's not feasible. So I'm going to do the best I can.
Okay, now, you were given a judge's explanation of rights to defend this without an attorney, right?
Yes, sir.
And as a defendant, it states here, as a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Do you understood that option?
Yes, sir.
Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent yourself or to represent you. Did you understand that option?
Yes, sir.
Now, based upon the statement that you just made, something about not having unlimited funds, you would hire an attorney. If you, I guess if it didn't require unlimited funds, did you try to hire an attorney?
Not yet, but
I mean, so how do you
through a divorce right now too, so I'm spending money on that.
My question is, if you haven't tried to hire an attorney, how do you know you can't afford to hire an attorney?
Because I had to hire a divorce attorney, so I know that.
So maybe, but you hadn't talked to an attorney about this case, have you?
No, sir. Not.
And you haven't filled out an affidavit of indigence for the court to determine whether or not you meet the eligibility requirements. Is that correct?
Correct.
So the question is, I'll just ask this second question again. Is your decision entirely voluntarily on your part?
Yes, sir.
Okay, so I find that the defendant has knowingly and voluntarily waived his right to counsel, and I would therefore permit him to represent himself. Okay?
Thank you.
So your case is going to be reset, give you an opportunity to hire an attorney. You're going to stand on the X in front of the court coordinator. And once she's going to reset your case. Once your case is reset, you'll be free to go and you have a blessed day.
Thank you.
All right. Hope Richard. Mr. Richard, would you please raise your right hand? Ms. Richard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Ms. Richard, you may put your hand down. Ms. Richard, I have before me a document that is titled Information, and this information alleges that, well, let me do this here, let me back up. Now, Ms. Richard, you have a right to have a record dictated by the court reporter, or you have a right to have a court reporter to type everything down. You also have a right to waive your right to have a record. Do you waive your right to have a record in this case?
What you mean by waiving
Oh.
the record?
Okay, you have a right to have a court reporter, like a secretary typing down everything that's being said.
Okay.
Everything I say, everything you say, everything that's being said in a courtroom. You also have a right to waive your right, which means to give up your right to have a record, which means there will not be nobody in here typing down what's being said.
Okay.
Okay. Do you understand that?
Yeah.
So do you want a record? Do you waive your right to have a record?
This waiver.
All right. Now, Ms. Richard, I have before me a document that is titled Information. This is a document that was filed by the Jefferson County District Attorney's Office. In this document, it alleges that let me do this here. Give him he's gonna set it for an announcement because he has to have some time to get discovery. Okay. Now, and give him about at least no less than 60 days.
Okay.
Okay. Now, Ms. Richard, in this document that's titled Information, it alleges that on or about June 27 of 2022, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify fugitive from justice. Ms. Richard, do you understand what you've been charged with?
Yes, sir.
And to this charge, Ms. Richard, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty freely and voluntarily?
Yes.
And are you? Yeah. Are you, and you're pleading guilty because you are guilty, is that correct?
Yes.
Ms. Richard, I have before me a document that is titled actually it's titled Misdemeanor Plea Admonishment. It's also labeled as State's Exhibit Number 1.
Mhm.
Do you recognize this document?
Yes, sir.
On page 2 of this document, there are 2 sets of initials, HR. The first set of initials is on the line next to a box that's checked guilty. Ms. Richard, are these your initials next to the box that's checked guilty?
Yes, sir.
The second set of initials is below a paragraph and next to a statement that reads, I do not request discovery of the evidence and I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Now, Ms. Richard, are these your initials on this line?
Yes, sir.
On page 3 of this same document, Ms. Richard, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court, let me see. Let me back up. Now, on the second document that's titled Trial Court Certification, the Defendant's Right of Appeal, is this your signature?
Yes, sir.
And on this signature it says Hope Richard. The document we previously had Hope R. So we just need you to complete your signature. Now, Ms. Richard, before you sign, I've got another one. The next document is titled Trial Court Certification of Defendant's Right of Appeal. Do you recognize this document?
Yes, sir.
And is this your signature on this document?
Yeah.
On the top of this document, there are two boxes that's checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that?
Mhm.
Now, Ms. Richard, before you sign an initial, let me see. Let me go back over these documents. Now, we have two documents on paper. The first document is titled Judge's Explanation of Rights of Defendants Without an Attorney. And is this your signature on the line that's titled Defendant?
Yes,
And are these your initials on the line stating you want to waive your right to an attorney and represent yourself?
yes, sir.
The second document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. You recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Now, Ms. Richard, before you sign all these documents that I've just mentioned to you, did you read the documents? Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge? Ms. Richard, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. And I will also find that your plea and waivers were freely and voluntarily given. State, oh, well, Ms. Richard, are you a citizen of the United States?
Yes, sir.
Now, state, you like to offer state's exhibit number 1?
Yes, Your Honor, would.
Ms. Richard, the state is offering state's exhibit number 1 to be used as evidence against you in your case. State's exhibit number 1 is the first document that is titled Misdemeanor Plea Admonishment, which is state's exhibit number 1. It's all, this document is the document that have your initials that you acknowledge on page 2
Mhm.
and your signature that you acknowledge on page 3. Is it all right for the state to use this document as evidence in your case? Okay. No objections. State's exhibit number 1 will be admitted. Now, state, do we have a plea bargain agreement?
Yes, Your Honor, we do.
What is that agreement?
Ms. Richards spent 2 days in jail, and the state would like to give her credit for those 2 days in jail and tax and entire court costs.
Court loss. Oh, man. So the state is offering 2 days to be served in Jefferson County Jail. You already have credit for 2 days. And the court cost in this case is $292. Well, yeah. And now you get 2 days that will go toward the $292. And that'll leave $92 to be paid. Are you able to pay the $92?
Yes.
Okay. And so we'll give you until the 20th of December to pay the $92.
Okay.
And now-
I wouldn't, if I'm not able to pay it, what were the other?
Well, you have to, they'll issue what they call a capious pro fine, which means you have to sit it out.
Okay, no. So I sent it out for Christmas and I'm pregnant, I'm pregnant too. So.
Yeah. Yeah, okay, so, yes, it's $92. I mean, you sit it out, or if you can't pay it, then we may have to convert it to what is called community service.
Yeah, okay, that's what I was asking, that's what I thought you was doing.
Right.
Options would have
That
been.
would be an option, but if you say you can pay it, we'll give you an opportunity to pay it. And then we'll cross that bridge, when or if we get to.
I'm gonna just end the thing.
Okay, so, now do you understand the state's offer?
Yes,
You
sir.
think the state's offer is fair and just?
Yes, sir.
And do you accept the state's offer?
Yes.
Okay, I'll follow the plea bargain agreement that you have entered into with the state. You're gonna stand on the X next to, right
And I got
here in front of the court clerk, right here on the first X.
And I got the 20th, right? But I
Yes,
can still come make the payment before.
before, yes, you can. And,
Taking my Christmas.
oh, well,
Oh, well.
yeah, that's,
That's the law.
yeah, that's just one of those things. But,
I understand.
I understand that, you said you're pregnant.
Yes, sir.
How far are you?
Only 2 months.
Oh, okay, so you got about 7. Well, we hope that you have, a healthy child.
Yes, sir.
Make sure that we pray that you don't have any complications during your pregnancy,
Yes, sir, thank you.
and you have happy holidays.
Yes, sir. Y'all too.
All right, you have a blessed day. Jefferson County Court at Law number 2 is back in session and calls number 333-164. Case is filed in the state of Texas versus Mark Anthony Owens. Mark Owens was scheduled to be in court this morning for the court's arraignment docket, which was scheduled at 9 a.m. on today's date of December 6th of 2022. At or about 9 a.m., the court's bailiff called the name of Mark Owens at the courthouse door. Mark Owens did not answer. Mark Owens has not appeared in court since the court has been in session. The court has been in session since 9 a.m. The time now is 12:05 p.m. on today's date. Mr. Bailiff, would you please call the name of Mark Owens at the courthouse door? Is that
I
one?
believe you were correct.
105.
105.
Yeah. Okay, it's 105.
I know it's hard to believe.
Yeah. Mark Owens' name was just called again at the courthouse door. Mark Owens did not answer. A reasonable time has passed to give Mr. Owens an opportunity to appear in the court. He is not appearing in court. State, you have a motion.
State moves for forfeiture bond and warrant.
That motion will be granted. Mark Owens' bond will be forfeited and a warrant shall be issued for his arrest. And cause number 333-164. Next case is cause number 333-238. Case is styled the state of Texas versus Deanna M. Mitchell. Deanna Mitchell was scheduled to be in court this morning for the court's arraignment docket scheduled at 9 a.m. At or about 9 a.m. Deanna Mitchell's name was called at the courthouse door. Deanna Mitchell did not answer. When her name was called at the courthouse door by the court's bailiff, Deanna Mitchell has not appeared in court since the court's been in session. The time now is 1:06 p.m. on today's date. Mr. Bailiff, would you please call the name of Deanna Mitchell at the courthouse door?
Deanna Mitchell. Deanna Mitchell.
Deanna Mitchell's name was just called again at the courthouse door. Deanna Mitchell did not answer. A reasonable time has passed to give Ms. Mitchell an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
State moves for forfeiture bond and warrant be issued.
That motion will be granted. Deanna Mitchell's bond will be forfeited and a warrant should be issued for her arrest in cause number 333-238. Next case is cause number 333-252. Case is South State of Texas versus Dantavian Jamal Collier. Dantavian Collier was scheduled to be in court this morning for the court's arraignment docket, which was scheduled at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Dantavian Collier at the courthouse door. Dantavian Collier did not answer. Dantavian Collier has not appeared in court since the court has been in session. The time now is 1:08 p.m. on today's date. Mr. Bailiff, would you please call the name of Dantavian Collier at the courthouse door? Dantavian Collier's name was called again at the courthouse door. Dantavian Collier did not answer. A reasonable time has passed to give Mr. Collier an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
State moves for forfeiture bond and warrant be issued.
That motion will be granted. Dantavian Collier's bond will be forfeited and a warrant should be issued for his arrest in cause number 333-252. And this will conclude the calling of the court's arraignment docket scheduled for 9 a.m. on today's date, December 6th of 2022, County Court at Law number 2. Judge Terrence Holmes presiding. Everyone, please have a blessed day.